Welcome to BDO's Legal Tech Talk podcast. We're joined by judges and legal professionals to discuss emerging trends, regulatory updates, and the latest headlines. We'll provide tips to help your law firms and legal departments make the most out of legal technology. I'm Daniel Gold, BDO Principal and eDiscovery Managed Services Leader.
And I'm Eric Dirk, BDO's Managing Director of Legal Operations. Let's get started with this episode's exciting discussion.
And welcome back to another BDO Legal Tech Talk podcast. Today, I am really excited to finally welcome into the virtual recording studio Clinton Sanko, shareholder at Baker Donelson Law Firm and the firm's eDiscovery and Document Review Officer, also the managing shareholder of the Chattanooga office. Now, I have to say that it's fair to say that Clinton's career trajectory at Baker Donelson as a commercial litigator with an emphasis in labor markets, non-competes, trade secrets, antitrust, highlights a very distinguished professional journey marked by significant leadership, industry recognition, and always an eye toward technology. Now, the reason why I say finally is because, as we talked about before we started the show here today, Clinton and I have known each other for about 20 years, and today get the opportunity to share with our listeners what I've always known about Clinton, and that is he leans into legal technology in a thoughtful and innovative way that drives higher levels of thoroughness and efficiency, which always translates into a higher value for clients. Clinton, welcome to the program. So happy to have you on here.
Thanks so much, Daniel, for that introduction. I'm excited to be here and have this conversation with you and Eric today.
Fantastic. So here, I'm going to start off with what will not be a softball question, but something I think will really frame the whole conversation for us. Look, you have spent your whole career at the intersection of litigation, and you have seen the evolution, as I have, because you and I are graduates of law school roughly around the same period of time. You have seen the evolution of legal technology, the evolution of the federal rules, and yet you fast forward all these years later. What is the single biggest blind spot that you are seeing in law firms and corporate legal departments today, and how they are approaching eDiscovery, and what's at stake, Clinton, if that blind spot is not addressed?
That's an excellent question, Daniel. As I look at what is possible with eDiscovery right now, and particularly with the growth of data volumes and the variability of the types of data and collections, I think that information governance, one, would be a major blind spot. But what I would say is when you look at an eDiscovery project, where the most value can be brought is lawyering it better, getting better agreements, getting better scoping, understanding the universe of your company, and drilling down to what's really important and negotiating for that in the context of litigation so that you can find what's proportional and do what's right for the litigation, but being mindful of proportionality and how that applies in that lawsuit and in that data environment just takes really good, sophisticated, on-the-ground lawyering of that problem. And I think that that's the biggest blind spot that we see with cases that seem to go awry.
Yeah, that's awesome. And having a lot of IG experience in my background, one of the things that I'm starting to learn with agentic AI in general, but also agentics, is this idea that is a game-changing idea, which is the reimagination of records management. The idea that you have academically correct policies that have oftentimes struggled to be fully implemented, but now you have this ability to identify content with a machine, human-in-the-loop identification. So we've seen a lot of evolution with PC, TAR 1.0, TAR 2.0, but we also struggle with adoption. How do you think that AI, outside the context of discovery, in the context of IG, information governance, how is AI going to actually help us think differently about how we address specific types of matters from a custodian lens versus a classification lens? So really, really kind of like that's one of my top of mind thoughts right now.
So if you think about Gen AI applied to that custodial lens or topical lens about the data, it's going to give us the ability to sit on top of larger data sets and query and think about that story differently right from the very beginning. So not thinking about it like an e-discovery project that you're scoping by custodian and time frame, instead thinking about the merits of the lawsuit and what actually matters, and sitting on top of existing extant client data and doing that querying. I don't think we're quite there in terms of being able to do that iteratively right this minute, but that is clearly in scope of what's coming down the pike. And I think that that's going to enable just an entirely different mindset about advising clients at the very beginning of litigation and how we go about doing what was traditionally called early case assessment. But when people said early case assessment, it carried with it these connotations of, I'm going to go collect a little bit of data, I'm going to iterate with that data and figure out what's going on. Here, it just opens up the entirety of the company to that iteration and to that early case assessment. And that's just going to require a different type of thinking and a different approach at the very beginning of the case, because Gen AI is going to empower entirely new ways of solving these problems for our clients as we look at what is now possible with this new technology.
So I helped start the EDRM models back in 2004. And, one of the things that we really struggled with is breaking free of a linear idea about, you identify, you gather, you run it through a factory, you evaluate it, and then you kind of hand it over. But with Agentics, we almost see very much like a DNA model, where we have this cyclical return and it's progressive evolution, and it is linear, but it's always kind of feeding back on itself as you learn more. So I think the promise of what Agentics is going to do and what AI will do is it'll keep informing us. From a legal strategy standpoint, we're not going to be able to just set down and set aside a specific argument anymore. We're going to have to reintroduce those arguments as we learn more about data, custodians, events. I think having worked in law firms and law departments, I think the traditional linear model is really needing to be readdressed. I just don't know, Clinton, if people are actually going to be able to wake up to this. So just generally thinking, how are you going to challenge your clients to think differently about the services that you provide in the context of litigation?
Those are all excellent points, Eric. And before I address that question directly, I want to talk a little bit about what I see as removing of barriers for the more senior lawyers. So historically, you've had an army of people in between you and the data as the senior lawyer in the case, and you tend to get curated sets of things or curated ideas based upon instructions that are very, as you said, linear, that are gone out and found and reported back. This just removes all of those barriers to the data for the senior lawyers, for the substantive experts, for the trusted advisors to directly query data. Once you learn how to prompt, you're talking with the data set, and that is net new. I think that as well, and I love the idea of the information loop changing and it becoming more of a keep informing us. I think that's a very valid insight. And I think you'll see we'll start to create stories, but then you're constantly testing those stories as you get new endpoints, as you get, say, for instance, third-party productions, or you get additional deposition data. It's constantly revising that story just naturally as that information comes in. So the challenge for both the lawyers within the law firms as well as for the clients, to directly answer your end question, really comes down to understanding the potential to unlock entirely new ways of solving the problem. So those people that use AI to basically automate what they're already doing and just replicate what they're doing are only going to capture a fraction of the value of AI. It's going to be completely unlocking litigation in a different way, because now we have these new tools that are going to allow us to do new things and solve old problems with entirely new methods that just were not possible under the old extant billing hour. So it's just going to open up and unlock all kinds of new potentialities for how we solve these problems and how we advise our clients.
There's so much to unpack there, Clinton. Okay, so let's talk about this. First thing I want to talk about, and I will not ask you a compound question, counselor, but I will start with, I think really the top level idea here is this, is that you're talking about this concept of talking to the data set, about asking the data set question. We are still caught up, though, Clinton, in this world where many attorneys who have been practicing for 20 plus years are still dealing with printouts of the data, that they have massive copy centers and they are looking at manual copies and they're literally thumbing through page after page and highlighting and putting sticky notes on all this. What you're talking about is akin to a flying car versus I'm in a horse and buggy. There's two ways of lawyering there. And you are clearly on what I always say on the cusp of, I'm going to call it doing it right, to have value-based billing methodology. You've got an outcome to delivery faster. You're telling better stories about the data, but there's still all these other lawyers all in the country. They're manually going through paper. How do you get to at least a middle ground, Clinton?
In my private time, I use ChatGPT a lot too, and I was actually struggling with that very question, right? Because the beautiful thing about an AI engine is its conversation, is the back and forth, the querying, the thinking through new ideas, having it present to you new thoughts that you would not have thought about were it not for that conversation. But at some point, you have to extract it out of that back and forth Q&A into a piece of work product, whether it's back to Evernote or something else. For some lawyers, I think having the tactile piece of paper still has value. To have a binder with the 20 key documents that you come back to in a case still has value because that's physical, that's real, and you're engaging with it through a different means than a screen. And so I think we're going to be figuring out over the next year or two, where is the value for when you reduce a conversation with the data or an output out of a legal tool that's drafting you something, and then you turn it into a Word document that then you're working with within a different structure. And I think you're going to see these information systems serve different purposes, whether it's discovery, whether it's finalization, or whether it's actually reducing something down to an exhibit set that you then are working with in paper. It's just a new means of query. It's a new means of looking at and engaging with data that's net new, which just didn't exist before. I love a prompt, right? Because as a discovery lawyer, I go, if there's an important document in a case, what would you rather have, the prompt or the output of the ChatGPT or whatever the Gen AI tool was? You'd probably rather have the prompt, right? Because the prompt says, here's what I want you to do. Here's the tone that I'm looking for. Here's the persona that I want you to undertake. And here's the background that I'm giving you to draft that. It's going to draft it different every time, depending on the model that you're using, depending on how you're engaging with it. But that prompt, that is gold. It's money, and it's a new way of engaging. And so I think what we're talking about here is just a new spectrum where you start with a conversation with data, and then you're struggling with when do you reduce that to the Word document or the spreadsheet that we traditionally work with, and then how do you reduce that to paper? There's always going to be a place for those different things, but I think the discovery happening in paper is absolutely dead. That the discovery with paper is dead. You have to do that within these engines because there's just too much data and there's just too much noise that's hiding your signal.
One of the things that you said just now, which is great, which is you love a good prompt. Eric and I spend a lot of time throughout the day as well, and also in off hours, going through and prompting. And one of our recent discoveries, recent as in the last 48 hours, recent discoveries is that the way that we've been prompting, and we both hold ourselves, I think, to a high degree of being able to leverage Gen AI tools in appropriate ways to be able to derive the outcomes by which we are looking for. But one of the things that we found is that you can draft a prompt in a way, in a scientific way, in an art and a scientific way, that is long form narrative that goes along the lines of what is the role, what is the context, what are the constraints, what are the goals that you're looking for? What are the instructions that you're telling it to? And most importantly, what's the output format that you want? I think that 95% of people who are utilizing Gen AI tools today probably don't really appreciate that. And it affects whatever answer. Very similar to how a good litigator in a deposition or at a trial, if they don't ask the right question and fill it with context and instructions, you're not going to get a good answer. So how have you been able to figure out, Clinton, that a good prompt is not the same as doing a internet search engine search?
The short answer is I started using it, and I used it for virtually everything. I use it for personal things to everything from asking you questions about an art museum that I intend to go to and engaging with art, to parenting questions, to using it in my legal practice with our approved tools within the firm that are, approved by security and for client data and client consent. So it is actually just using it. And what I have found to be the coolest thing about using any Gen AI tool is it really will match your energy, right? If you want to put a case into a Gen AI engine and say, summarize this case, it will absolutely meet your energy and it will give you a high level summary of the case. It will also draft your LinkedIn posting that has 150 words, that has a cultural comparison that's appropriate for LinkedIn, that has the tagline at the beginning of it where you cause the hard return. It will do what you tell it to if you take the time to engage with it. But in my experience, it's really just using it. And I will still have moments, as I'm sure the both of you do, really probably every other week, but more likely weekly, where your hair actually stands up on the back of your neck and you say to yourself, I can't believe it just gave me that result. It was so fantastic. And you run up and tell your wife. And it's just, that just happens all the time when you're actually engaging with these tools. And it's really special. It's a net new experience using technology. Just really doesn't happen before.
Right on. And I guess, Daniel and I, as you mentioned, we have a beginner's mind with prompt engineering, right? We've read about it for a long time. The question I have for you is, when you're prompting and you're doing what is essentially the beginning phase of a research project in whatever context, how disciplined are you in, and let's say that you're doing litigation memos, prep and response memos, how important is it for you to follow the same prompt structure? Or do you use it in more of a creative way based on conditions and narrative that you've been told about? Because what I'm learning, and my hypothesis right now, is the structure is critical if you want to have consistent performant outcomes. But then again, there's an art to this. So just how do we strike a balance between science and art? And then how do we convey it? And will there be standards for prompting of specific types?
Well, there's so many Gen AI tools that either are, for general purposes or then are for skill specific purposes, right? So the skill specific tools, I think, are going to be very important to have a structure and a system by which you're using them. The general tools, I would say that we definitely will have prompt libraries that can be then reduced to the instant issue you're trying to address. But I think that the general purpose tools are going to still be a lot of interrelationship and engaging with it. And I think that one of the things that when I hear your question, I go, what is it that I'm trying to do? Because when I look at a certain Gen AI tool, if I'm just trying to ideate, I'm going to talk to it a particular way. If I'm trying to build a very specific type of work product that's going to have a specific purpose, I'm going to get much more granular. And I think as we come up with use cases for, say, for instance, deposition digesting in the context of road accidents for a trucking company, I definitely think that you will build a very specific prompt that you will then reuse in that repetitive litigation setting. And so a lot of it's just purpose driven, right? Because when I think of a prompt or a use case, I go, it's endless. It can do virtually everything up to and including talking, right? And so how can I leverage that? It's just, there's so many use cases right now that the prompt libraries, I think, are very kind of in their infant stages, but I think we're definitely going to get there where we have a lot of structure around prompting when it's for that very specific purpose and it's repetitive, particularly when it's repetitive.
Yeah. One other thing that I'd add, or maybe question, is there is this idea of over-engineering. So one of the things that Daniel and I are learning is, it's one thing to have a compound statement about what you want as an output, but sometimes you can direct the tools in such a way that you create this myopic output. So at what point do you think the balance needs to be struck with, because we're really talking about like art versus science, but what I'm learning is like, I asked the question too precisely and it didn't give me all this other stuff that I would have expected. So how do you deal with that? And one of the things that I really want to know is, how do you kind of not restrict the creative process of being a lawyer with AI? Because that's really like what I'm struggling with. What do we do with this?
I think that comes from just experimentation, Eric. And I will say that one of the things that's really helped me is I've narrowed down the tools that I use on a daily basis to just a couple that fulfill the 80% of my needs so that I can learn how those particular engines work. And so when you're working with more of a tool that's specifically driven for a legal consumer and is built for a legal consumer, one of the things that is really important is finding the right set of data for that engine to react to. So what pleadings you put into it and tell it to engage with that relates back to your prompt. That's one way in the legal setting that you can be very careful, is restricting what data that it's reacting to, and that will drive better work product. I have had the exact same experience as you, where you over-engineer a prompt, and what you end up getting is almost your prompt back to you in some ways with very little exercise of what we like to think of the freedom of AI to give us new ideas. And so that balance is just going to come with a lot of practice and engagement. We are adding a new team member to our team. And this team member is like no other team member we have ever had, that will take our feedback, that doesn't require a lot of rest, that can absorb and reiterate in a way that human beings cannot. But we have to learn to talk to it. And that's just going to come almost relationally, to learn what it reacts best to and how it works best, and then sharing that within your circle so that the rest of the practitioners around you can benefit from that.
Legal teams are struggling to manage resources, maintain compliance, and adopt new technologies. BDO's legal operations team can help. We enhance efficiency, reduce costs, and support compliance so you can run your legal department like a business. Schedule a meeting with us today at BDO.com.
So now let's bring it back to the day-to-day. Opposing counsel submits their discovery demands. And amongst those discovery demands, Clinton, I want you to give me your prompts. How did you use Gen AI in order to be able to surface up said documents to us? And we want to know whether or not you biased the Gen AI in the prompt. It could be any e-discovery platform, fill in the blank with whatever company name who's leveraging Gen AI. What do you say to opposing counsel who says, Clinton, I need your prompts?
Well, the first thing I would do, Daniel, is object, because I'm the lawyer in the case, and that's completely inappropriate for you to try to get my work product. So we would start there. But in terms of the underlying client prompts, I think that that's going to have to be dealt with in the e-discovery space, because it is data. If it still exists, it likely is discoverable to the extent that it relates to the claims and defenses in the case. And so it will need to be discovered. But I think the discovery will happen, and we deal with new sources of data all the time, just like we had to absorb social media when it first came out, and standards develop over time, and that will happen for our prompts. But I think the more important point here is understanding that when you are hearing about output out of any AI tool, it's very difficult for you to engage the output of that tool without understanding both the prompt as well as the environment that the prompt is exercised in. So if it's for instance, a lot of these publicly facing Gen AI tools, you would almost need the settings that were applicable to that user. Like, what did the user tell ChatGPT how to engage with the user or whatever that tool is? And then you have to understand, is it session specific? And so when you're hearing news stories about something that an AI engine did, you can't really absorb what that AI engine did without knowing what the prompt was and the environment in which that prompt was operating. And those are going to be very, very difficult things for us to deal with, both culturally and then within the specific confines of a lawsuit as we look forward.
But you said something just now that I want to circle back to. You said at the very beginning, I'm the lawyer and that's work product. So I want to hone in on that, because it's an actually really important point, because opposing counsel constantly demands, what are your keywords? What did you use in the keyword search? And in the ESI protocol, you'll agree upon keywords and you'll say, okay, these are the things that we'll utilize in order to find the relevant documents. But you have created a bright line distinction just now in saying, whoa. My prompt is not a keyword. It's attorney work product. So how do you differentiate the two?
Well, the example that you gave had some ambiguity, which caused me to make that kind of jest about like me being counsel of record and not necessarily a custodian. But you're honing in on an e-discovery question that is something that the bar is going to have to deal with, right? And so it's that question of the discovery of a prompt that was used to generate a set of responsive documents, right? And so I think you'll start to see that being dealt with in ESI protocols and through negotiation, because the carrot for the defense bar is the certainty of, once I do this exercise, I have a compliant production that allows us to get to the merits of the case and move past the compliance exercise of a document review. And so that's why the keywords are given over a lot of times in that context, because it allows the parties to get to the certainty of agreement. And so the discovery of a prompt that is used to generate a set of responsive documents, that is something that the discovery bar is going to have to deal with. That is fundamentally different than a lawyer engaging with data and through their very prompt asking a specific question about a pattern or an event or a person, or stress testing something. That's fundamental core mental work product that would never be discoverable. It would be similar to you, although I don't think of any of these Gen AI tools as a human being, but you would never discover the instructions the shareholder gave the associate in order to write the chronology that led to the summary judgment brief, right? That would never happen. And so it's very similar to that when you're deeper into the confines of the actual creation of work product in the context of a lawsuit.
All right, so here's the $1 million question. In the world of keyword disclosure, we could say that, yeah, it's fairly static. You know, you're actually producing words, maybe variations of terms, proximities. And if you got really advanced, you could even assemble some concepts. It's basically where it's gone today, right? Where we are today with text-based analytics. Now we have this ability to have a machine help us do all that stuff, but also define concepts for us. And now, where does the machine start taking over for the thinker? Because when I write prompts today, a lot of times, you know, I'm under a time crunch. I'm trying to get an outcome, deliver an output that's, I think, reasonably okay. Remember, I'm not a perfectionist. I try to do things effectively and efficiently with as much information as I can. But at what point do we start over-relying upon tools to deliver outcome? And at what point does thinking and deliberation take a backseat to that?
No matter what tool we're using as lawyers, to the extent that we're using information to advise or give our professional judgment or recommend to a client that a particular course of conduct happen, it is up to us to determine where we need to be in terms of our certainty on the underlying facts of any given thing. And so we would have to, I think, however much AI is going to unlock litigation and new potentialities, ultimately the human judgment and the legal judgment and the professional judgment has to lie with the attorney that's making those recommendations. And so drilling down to what it's basing it on and using other sources to stress test the AI and the thinking absolutely is going to have to happen. And that's one of the core principles when you look at a lot of the ethical advice coming out for lawyers. It's drilling down, it's checking, it's making sure that you're understanding what the AI is relying upon for a particular factual, representation. And is that in fact reliable? It's where the hallucinated cases come in. That's the perfect example, right? It's a lawyer puts something into a Gen AI engine and it spits out a statement of law, and then it has these fake cases. And I look at that and I go, well, the feature in that is the law that it's predicting, right? Because that's something that you probably should look at as a lawyer. You should calibrate that in a recognizable, legal database and test that and research it. But the fake cases just show reliant judgment on an engine that hallucinated something. It just shows a lack of professional care. And that's what people are reacting to. It's that not testing, not ultimately retaining your professional obligations to drill down into what that engine is relying upon. And that's going to look different in every circumstance. There's no way to make a bright line rule other than to say you have to test those important things, anything that's material to the judgment that you're exercising on behalf of your client to make that recommendation to them.
So this is good because this is somewhere I want to go now, Clinton, because now what you're talking about is this idea of this lack of professional care. So we often talk about a lot about how you have to be competent. So we've all talked about this, several times over. The ABA even had to push out guidance to remind everybody that you've got this competency requirement under Rule 1.1. Okay, the Rule 1.1 being the rules of professional responsibility for those following along here. And so you have this competency requirement, and the input that some lawyers are doing is like, oh, okay, cool. I get how this Gen AI thing works. It could shortcut a lot of time. I could just type in a bunch of stuff. It would give me an output. I'll copy and paste it, and I'll throw it in, and I'll submit it to the court. So the lack of professional care you're talking about is that there's actually, one could reasonably argue that there is still a lack of competency in understanding how the tools work by simply copying and pasting, throwing it in there, and sending it out the door because they are over-relying upon judgment that is not a lawyer. One can actually say that Rule 5.3b of the Rules of Professional Responsibility say that all these Gen AI tools are not lawyers, and therefore there's a responsibility for lawyers to learn. We had a lawyer tell Eric and I once that, Daniel, Gen AI is no different than any other technology and any other shortcut process by which if a senior lawyer receives output from an associate and just signs their name to it and submits to the court without looking at it, it's the same effect of going through a Gen AI tool, getting the output, signing their name to it, and submitting it to the court. Either way, there's an irresponsibility. So the lawyer that's going to do it before is the lawyer that's going to do it now is basically the argument. I mean, do you buy into that argument? Is there still a lack of competency even if a lawyer is using this tool?
So I definitely think that the signing lawyer has a Rule 11 obligation to look at the facts and the law and make sure that there's a reasonable basis for the facts and that the law exists, or you're making an argument for a reasonable extension of it. The way that you satisfy that in day-to-day practice will vary by circumstance and by the team that you have around you, of course. But when you're looking at AI, to accept an AI output without any stress testing of it, I would say that that would be something that would be very, very dangerous from an ethical standpoint and could lead you down a really dangerous path. Where I thought you were going with the question, where I think is a really important place to go to, though, is just the competence in the ability to prompt what would be a reliable output, or even to engage with the tool and the practice that that takes. And I think that where we're going to be talking about competency a lot, once we get through right now, the big talk of competency is the signatory to a hallucinated case brief, right? But I think we're going to be talking soon about the competency of understanding how these tools are working, understanding what Gen AI is actually doing in terms of predicting a textual response to what you're saying, understanding how that works and practicing with it. And I think you're going to see some things come down the pike in terms of ethics about those lawyers that really didn't understand how the tool worked and relied upon it in a way that factually, situationally, has some errors around it. And they're going to be looking at those circumstances as well in terms of how they use the tools to generate those results.
One of the things that, if you read the e-discovery papers that we're hearing about, is this death of first pass review. And, I guess last fall, this metric that says, hey, 98% accurate, it took us just a couple hours to tune. So what would have been, weeks and weeks of doc review for maybe 8 to 10 people at a super high cost is now essentially obviated because you can do it with a machine. Coming from the law firm perspective, how do you think the discovery practices and the billables are going to be impacted? And are you seeing law firms embrace or maybe push away some of these more kind of, I guess, what's becoming commonplace routines of accepting and adopting AI because they're afraid of losing a billable hour?
That combines a couple of different concepts in there, Eric, and it's an interesting framework to think through. When it comes to the automatable tasks, right, the binary decisions that happen within a document review, those have been subject of discussion for as long as I can remember. It's the reason why we had continuous active learning and predictive coding before that develop. It was always around those automatable things that technology seems to be able to replace and replicate what the humans will do. But what the machines can never replicate is trust, judgment, experience, and applying the law to an individual client's dilemma and advising them on how to navigate treacherous waters that could lead to litigation or lead to a great output. It's just changing the way that you might find the information on which you base that judgment. So one is this reducing barriers for the lawyers to engage directly with the data, which I think is quite lovely and is just net new and has never existed before. And so like those lawyers that have that judgment that the machines are just never going to replace relationship, that is one, it's going to enable them to get into the data so much faster. And then in terms of the way that we look at a lawsuit will be completely unlocked and different than it ever has been before. So when you get a complaint, you now all of a sudden can look at that complaint through a different lens. You can put it through a series of prompts to create timelines, to create interview outlines, to create the first phase project plan, things that you could have never done before. You can run it through. I think we're just not that far away from saying, draft me a motion to dismiss. Okay, draft me the response to the motion to dismiss. Take that draft response to the motion to dismiss, revise the motion to dismiss. Do that over and over again until you've reduced it to the best version of a motion to dismiss and you know exactly what facts are going to be the key things. And then go and look at the way that court has decided things and tell me how I should posit those facts in this brief. We're just going to be able to iterate more quickly and do things that just were not possible. But at the end of the day, there is going to be a lawyer with judgment, experience in that matter, who is going to advise the client. We put it through this process, but you know what? More importantly, I think this is excellent. I've looked at the case law. I've looked at the facts we're relying upon, and this is the best chance that we have to position us for success. And I think that's going to happen just naturally as we look forward. The final thing I would say in terms of the billable hour, I find very few lawyers, and maybe it's just my firm, but I don't think lawyers sit down and say, how many hours can I bill for this? And then work to the max hours. I think most of us sit down and say, how can I create the best work product for my client that I possibly can? What's proportional to spend on this based on the needs of the case, the client's budget, the client's expectations, what I know they want from me, and then you work within that. And it never feels like we have enough time. And so I think these tools are just going to enable us to just practice at a much higher level because it's going to replace those things that were baseline things that we had to do to get to the value added work. We're just going to do them faster and we're going to spend money, but it's going to be on the value-added stuff that the clients want, and it's going to position us for more success.
This is the reason why I wanted you on the program, because I love the position that you're taking, and what you're doing is you're elevating the practice. And really what I'm hearing is, out of your voice, is this need to, or encouragement to get everyone else in the bar upskilled as well in what you know. Because this idea that you're saying without saying it is value-based billing, as opposed to the hourly bill. The billable hour rather. And what I'm finding though is that there is still a dichotomy, Clayton, of lawyers who say, if I use TAR, if I use CAL, if I use Gen AI, I'm going to lose my billable hours. I know and you know, but I want you to explain it though, why that is not the case. By leveraging tools such as Gen AI, by leveraging in how you said it about, I love that phrase, the lawsuit is unlocked. When you unlock the lawsuit in such a way, you are driving value. You get to outcomes faster, right? Please, can you help instruct us as to why that thinking is as antiquated as, utilizing keyword search to just do an entire matter today?
So it's hard for me to address a hypothetical that I don't live on the regular, right? But what I would say is number one, that's just missing the fact that data volumes are just growing at an exponential rate like we have never seen. I don't know exactly what year you graduated law school, Daniel, but for me, it was 2001. And when I started law school, we were still using paper. So my first year of law school, I used all of the books, right? And then I started practicing, and you use Westlaw and Lexis. Those were the major tools when I graduated. And that was like a totally different experience. But now, can you imagine with the amount of regulation, with the amount of case law, trying to do anything with a paper library? It just wouldn't even be possible. And then you flash forward and you say, my first piece of litigation, I remember crawling around finding boxes of documents. And it was a big deal when we sat in a conference room with 20 or 30 boxes. You literally would travel to a different city and you would do that, and you would tag them with Post-it notes and clips. I still remember a paralegal yelling at me for not being careful with how I clipped the documents, and it made it confusing. And so there is that. And now we use e-discovery tools, and we would never think of printing everything to paper and having people sit in a conference room. This is very similar. We have exponential data growth. We have people creating data footprints that are, I would say, 10 times as big as they were even 4 or 5 years ago. We have cell phones that are astronomically large in our collections now. And so these tools are just going to enable us to engage with that data in a different way. I talked to my kids and I said, well, if you don't have AI to do a broad-based lingual search, what you're going to do is you're going to find a couple of sources that are going to be very thin and narrow, and you don't know even what you're missing. AI is going to allow us to start to see what we're missing and engage with data sets differently. And I just think it's going to become a reality no matter what the pushback is around what is a perception around the economic models of a law firm. The final thing that I would say is it's just going to unlock work product for our clients, value work product for our clients. It just was not possible before the advent of AI. You couldn't draft a complaint and then before you filed it, put it through an AI tool and say, tell me what are going to be the top 5 things that they're going to argue are factually missing from this complaint that could matter to a motion to dismiss. And you're going to reiterate the complaint around net new work product that probably would have never been created if it was going to be based on the billable hour. So it's just going to unlock these potentialities for clients to get more value from us, regardless if it's based on value-based billing or an AFA, or if it's based on an hourly rate. It really doesn't matter because both of those are just surrogates for how we charge for legal services for solving these problems. But AI is going to unlock all these new ways of solving these historical problems, but also just giving us new tools and new ways of looking at things.
Just for the record, counselor, I would have graduated in 2001, but for the fact I took a year off. So I was a graduate in 2002. And yes, and my experience was the same. Paper-based when I graduated, books in the library, 100%.
When you go through your step through of content creation, content evaluation in the context of a legal function, what we are also seeing is I can now assemble feedback from a conversation very quickly. I can create concepts from that. I can go to a summary note 20 minutes after I have an hour conversation with somebody that's classified and categorized in a really articulate way. I don't need to go down a ladder of 5 people approving my notes anymore. I can say, yeah, I just ran this through Copilot and we're good. I can hear back from the client. Usually the delays are still the same, a couple, 3 days to get somebody to respond back to you, but then they'll sound like an SOW. In an hour, I can have an SOW because I'm working off of templates and prompts that are standard. So the acceleration is nigh. Like that's the thing that I think that I'm really grasping on what you're saying, because the acceleration is here. However, I wonder if there's always going to be 2 classes of individuals, those who are really embracing the do more with less, and those that are saying, hey, I'm good. I don't want to take on more than I can chew. And if I do more, people are going to give me more. So I think there's a balance, and I'd love to get your thoughts on like the personas that we're going to find that are adapting AI versus the personas that maybe not so much. So what do you think about that?
I think with any technology revolution, you have those that will be adoptive and those that will be reluctant, right? I mean, with social media, there was a whole string of lawyers that said, I will never use this. And now you look at LinkedIn and the usage of LinkedIn, it's the exception where somebody's not really on there or using it. It just became adopted over time. I think that there's a lot of advantages as a professional to being an earlier adopter in this particular trend. One of the things that I have been having just a ton of fun doing is creating a persona in a Gen AI agent that actually disagrees with me. And so I'll set it up to be a very well-educated person who completely disagrees with something that I hold dear and fundamental. And then I'll argue with it. And it's making me a better articulator of arguments. It's making me hold my feelings in check more because I'm learning to do that in a safe environment. And so, I can imagine a world where you're going to have a client meeting and you create the personas in an engine and you have the ability to see and to engage with them prior to that meeting. As you all know, because we talked before the podcast, I put your podcast page into a Gen AI tool, told it to train like it was the 2 of you, and then to ask me questions. which I answered verbally, and which it told me to talk in shorter sentences, not to be so convoluted. It gave me very candid feedback about my verbal speaking style to make it hopefully better for a podcast, which I'm sure all your listeners are now going, boy, he really didn't listen to it very well, or it didn't give great advice. But nonetheless, it is possible now. So it can make us better professionals. And so I would just encourage everybody, start using it in your free time. If you're not comfortable using it for the practice of law, that's fine. I get that. That is actually, there's a valid conversation around that, particularly if you don't have access to closed circuit tools. And we all know we should not be putting anything client confidential in a public Gen AI engine. But just start using them and see the power. Have it articulate some ideas back to you, and you will start to really see the value in making you a better professional.
I'm going to hit you up for that script because I think there's another person. Well, let's see. There's me. There's you. Oh, there's Daniel. Somebody on this podcast could actually benefit from that brevity comment. But anyway, Daniel, over to you.
I love that. So we've spent the whole podcast, Clint, talking about existing lawyers. But we're recording this in the summertime. There's a lot of summer clerks. A lot of the summer clerks are either 2Ls or they're 3Ls, and the 3Ls are going to look for a job soon. For the next generation of lawyers entering the field, I personally think that it's very exciting, especially for those coming up in the world that are shaped by AI, they're shaped by data. What do you believe this new class of lawyers needs to understand about the future of practice if they want to lead and not follow?
So what I would say again is to engage with it. So one way that a newer professional could engage with AI would be to train and tell a Gen AI tool that it is a shareholder at a law firm and model up the type of shareholder that you want to be. And then start asking it questions about what it would be doing right now if it was you, and tell it your circumstances, obviously nothing client confidential, but that'd be one way, is to think about it like a career coach and start to see what it would advise you to do. Another thing that I would advise our young professionals to do would be to do your best to create a piece of work product in an AI engine, obviously one that's approved by the firm. It has anything to do with client confidential information, but you could create any kind of work product and then compare it to a lawyer's that you really respect and see how well it did. And then think about how you can iterate with that Gen AI to get closer to what the lawyer you respect actually approved and filed in the case, and see how you can replicate that. I will say for Baker Donaldson Summer Associates, we actually got them all access to one of the Gen AI tools that we use internally within the firm, specifically because we think that is going to shape and impact their entire legal career. So the more they lean into it early, the more they think about creative ways of having it coach. Think about Copilot. You could put the email you're about to send to a partner and say, does this strike this type of tone that I'm trying to strike here? Do you have any suggestions for how to write more professionally? And it will help you do that and to learn to be a better professional much more quickly than Daniel and I could have possibly learned as we were coming up through, where we still had a lot of dictation happening, where we still had very little use of email in the early 2000s. So just think of it as an opportunity to engage with a professional that has limitless time, limitless energy to mentor you. And it does a really good job. I can tell you that because I've used it for those types of things a lot.
All right, Clinton, this has been a pleasure having you on the program here. As I said before, for all the reasons why I've been wanting you on the show, I think that you really proved that you've got such passion for being able to help your clients become more successful, get to outcomes faster. This is before Gen AI, but I think with Gen AI, I think you've really accelerated what you're doing at the law firm. I think you're accelerating what you're doing for your clients. And I hope that people listen to this podcast at least 3 different times, because the messaging that you've got here is just really fantastic. And we couldn't be more thankful for your time here today and for the messaging that you've given all of our listeners. So thank you again for being on the program.
Eric, Daniel, I really enjoyed it, and thank you all for having me on.
Thanks for joining us on BDO's Legal Tech Talk podcast.
If you're enjoying our podcast, don't forget to rate, review, and subscribe for more episodes.
On BDO.com, you'll find all of our episodes, transcripts, and ways to continue the conversation.
Until next time, this has been another episode of BDO's Legal Tech Talk.